All right, go ahead.
Just pursuant to 1791, where there is no conflict in the evidence, and the evidence introduced with all reasonable deductions and inferences therefrom shall be deemed a verdict of acquittal or not guilty, as the entire offense or some particular offense count. Starting with the aggravated assault count, the way Ms. Farris is indicted, she did then and there make an assault upon the person of Gary Wayne Farris with a deadly weapon, a handgun, by shooting Gary Wayne Farris with a firearm. The court has heard, nor has the jury, heard zero testimony that Ms. Farris either possessed a gun and actually held a gun, let alone fired a gun at or into Gary Farris. The only evidence is that there is a bullet, which, according to their medical examiner, he cannot say to a medical certainty that Mr. Farris was shot while he was actually even still alive. Even though he has certified this case as death by gunshot and homicide, he was still unable to tell us that he was alive when he was shot, how he was killed, any vital organs that the bullet may have passed through. Also under 1791, the defendant shall be entitled to move for a directed verdict at the close of the evidence offered by the prosecution or at the close of the case. Then if even if he fails to introduce any evidence, and we're going to be introducing plenty of evidence. If the court finds that the state hasn't met their burden beyond a reasonable doubt as to the aggravated assault, the aggravated assault is the predicate count for felony murder, so both of those will go away. So as to those, if there's no evidence other than Ms. Farris being at the residence on July 3rd, July 4th, in that time frame, is really the only evidence that says, is what the state is using to say that she is the one who committed this crime, if in fact there has been a crime committed at all. So they merely haven't met their burden as to an actual assault, considering there's actually no physical evidence that she assaulted Mr. Farris. There's no eyewitness evidence that she assaulted Mr. Farris. At best, there is just text messages and speculation that they were angry with each other over a vacation that he was buying for Chris Farris, and somehow that led to this alleged murder. But going back to just aggravated assault itself, they still haven't produced anything, even of where did she point a gun to him at, how, what time, maybe really even what day. And so for that, I think the count 3 should be a directed verdict. And if the court grants as to count 3, then count 2 goes with it. Concealing the death of another is much like the aggravated assault count by discarding and burning the body of Gary Wayne Farris. I don't think there's any doubt that Mr. Farris was burned. It is his body on the burn pile. However, there is zero evidence that Ms. Farris put his body on the burn pile. There is no witness that says that she put him on the burn pile. In fact, everyone that has testified, they're trying to make innuendos that the tractor was used, but there's no DNA in the bucket. There's no DNA on the back of the tractor. That the RTV was used. There's no DNA in the bed of the RTV that is linked to Mr. Farris. The only DNA on the tractor is on the step getting into the driver's seat of the tractor. Nowhere associated with the bucket on the tractor. So yet again, there's no evidence that she is the one who burned Mr. Farris's body or transported him there to be burned. Going to the malice murder count, did cause the death of Gary Wayne Farris, a human being, by shooting Gary Wayne Farris with a firearm. You get to the same thing. There's zero evidence that she shot him. They have put forward some, in my opinion, credibility issue witnesses saying that, coming out of the woodwork now, about how she got a gun. You've got Scott saying that he saw a gun, and now 6 years later, Jen is saying she saw a gun, and 6 years later, Chris is saying he saw a gun. All different types of guns, all different looking guns, but nobody can put a gun actually in Miss Farris's hand in her possession or under her control. Going back to the medical examiner, while he did certify it again as homicide and cause by gunshot, when I asked him very directly, is you can't say to a medical certainty that he was alive when he was shot. And he said, I cannot. So if you cannot tell me that the man was alive when the bullet entered his body, you cannot say that the cause of death was a homicide, or that he died. The cause being a gunshot, because you're literally saying he died from a gunshot wound. Then at the same time saying, well, I can't actually say he was alive when he was shot. They're just two completely contradictory things. I could sit up here and basically argue it all day. But for those reasons, we don't feel that the state has met their burden beyond a reasonable doubt to allow this case to go to the jury, at least as to the malice murder, felony murder, aggravated assault, and concealing the death of another. I won't be arguing about the making a false statement. We'll be making those arguments and close regarding that. But I don't think, I'm assuming what the court's most likely going to do is say, well, there's circumstantial evidence of all these things. But I would say that there is not circumstantial. There's circumstantial evidence she is there. And mere suspicion is not enough, and the court will charge the jury on that if we get to that point, that is not enough. That does not reach reasonable doubt. You have to have more than just suspicion. We have to have more than speculation and innuendo and people talking over text messages. There actually has to be some evidence. Regarding, I assume the state's going to get up and say, well, there's evidence of a violent crime in a house. No, there's not. The only evidence in the house is 2 drops of Gary's blood that were sent to the crime lab. And there is evidence to support that Gary might have been bleeding from a dog bite around that time. There's also evidence of Melody's finger bleeding. And there's also evidence of Scott being bitten by the rat snake, all around the same point in time. So there is no evidence of any type of violent crime going on. And for those reasons, Judge, we'd ask you to direct a verdict, not guilty, as to counts 1, 2, 3, and 4.
Ms. Frankish, you're going to argue?
Just briefly, Judge.
All right.
Probably not as lengthy as Mr. Ray. Just under 17.9.1, when the court is authorized to direct a verdict of acquittal, the court does so when there is no conflict in the evidence, and the evidence introduced with all reasonable deductions and inferences therefrom shall demand a verdict of acquittal. That's not the case here, Judge. I won't run through all the evidence, but as far as the evidence that has been presented for the past 3 weeks, there are a number of reasonable deductions and inferences from which the jury can find a guilty verdict in this case, and it's not the court's duty under a directed verdict motion to find that the state has proven their case beyond a reasonable doubt. That is the jury's job, but here it is just the court's duty is to would only demand an acquittal if there was no conflict in the evidence. And here we have many issues that can go to the jury. As Mr. Ray even stated, he has already deemed credibility issues with people. That right there is a reason for it to go to the jury. He has discussed issues with mere presence and the physical evidence found and individual statements and testimonies and where Ms. Farris was located. There is conflict in all of that evidence, and that, Judge, for that sole reason, this court should deny their motion. And also the inferences that the jury can make based upon the evidence that the state has already introduced, and as long as there is some competent evidence, even if it's contradicted, then the case should go to the jury, and that's what we have here, Judge. So I ask that you deny their motion for directed verdict on the counts.
All right, anything else, Mr. Ray?
I'll tell you this. If you direct a verdict of acquittal as to counts 1 through 4, now, 9 o'clock Monday morning, we'll rest.
As much as that might be a relief to myself and the jury, that's not the basis for one. All right. Although the evidence presented may be circumstantial, the test isn't whether I determine it's beyond a reasonable doubt. That's the province of the jury. It's based upon evidence most favorable to the state's presentation that a jury could find the defendant guilty beyond a reasonable doubt, and whether there's sufficient evidence to present that's been presented to the jury for the case to proceed, and I'll find that the state has met that standard. So I'll deny the motion for directed verdict. All right. Anything else for us to take up today? All right. Timeline-wise, y'all are looking Tuesday?
I think so. What our plan right now, I plan to have a majority of our witnesses here Monday morning at 9.